We are now on the record. Good morning, everyone. It is January 23rd, 2025 at 9:30 a.m. and this is a public deliberation of the Baltimore County Board of Appeals regarding case CBA 24030 and 21-250 ASA regarding Greenspring Joppa Falls LLC for the Greenspring Manor development at 2310 West Joppa Road. And we are considering today the developer petitioner's voluntary dismissal of the development plan and zoning petition filed by Counsel Adam Rosenblatt on behalf of the petitioner developer who is the appellant on December 3rd of last year. And we have received pleadings from the various parties, but just to restate the chronology of what's involved in this case, since it's lengthy. In July of 23, the ALJ denied the development plan and the zoning special variance request. On reconsideration, the ALJ in April of 2024 then approved an amended and combined development plan and zoning, and issued a combined development plan and zoning order after reconsideration. In August 2024, after hearing the matter, the Board of Appeals issued an order reversing the ALJ's approval of the amended and modified development plan and reinstating her original decision. And on August 21st of 24, we heard argument regarding the zoning case, the special variance, and deferred action on that matter, leaving the case open until any appeals on the development plan had been resolved. On August 27th of 24, the Baltimore County Council, in its wisdom, rezoned the property in part. And then in September of 2024, the developer moved for reconsideration and remand by this board to the administrative law judge. And then in October of 2024, this board ruled on the motion for reconsideration and remand, denying that motion and finding that the developer could withdraw its case and request dismissal at the board level, which the developer did in November of 2024, which got us to where we are today. And I think we are here to consider that. So I'm going to ask Mr. Stelmach to start the discussion. But I would say, just in proceeding, I think our rules might govern this situation.
Sure. Good morning, Madam Chair.
Good morning.
Good morning, Mr. Paulshock. I think that succinctly, I think that as far as the development plan case goes, that that case has concluded, that there is a judgment on the record there, and I don't think our rules let us withdraw or dismiss a case that's already been concluded. So that's how I feel about that. As far as the zoning case goes, I mean, I think it's still a live case. It's sort of a zombie case. Um, it's kind of just sort of existing shambolically. But uh, I mean, I think if this was a case that I had appealed from, let's say, like de novo from the orphans court to the circuit court, which is what I'm used to, and I asked to withdraw it, I'd be asking to withdraw the appeal, not the case. That might conflict slightly with our previous order to some extent, I guess, because it says that you can withdraw the case. I guess the question is, and this is what Mr. Wyatt suggests, is it's an issue of dismissal with or without prejudice. I guess the question is, what would the effect be of dismissing it without prejudice? I mean, I think to some extent the effect is the judgment of the ALJ stands at that point. Does the dismissal without prejudice allow the parties to re-bring an appeal? I don't know why they would do that anyway, but I don't think it would let them re-bring, well, except to the extent that they would be able to bring back their zoning case again anyway under the under the county code. They might be able to do that, but they could do that anyway. So I don't know. What do you think, Madam Chair?
Well, I think we're talking about Rule 3, and I would agree with you that the development case is concluded so that it can't be withdrawn. As to the zoning case, I think that we can dismiss it without prejudice. I think in the normal course, the developer could refile this either under our rules with prejudice in 18 months or without prejudice at any time. And I personally don't think it is our place to preclude someone from pursuing the use of their property as long as it's consistent with county code and zoning regulations. So if they can withdraw the appeal and the ALJ's decision were to stand, they would still be able to refile it and deal with whatever issues arise at that time, which are a whole different set of legal issues, which we don't have to grapple with at this deliberation. So my inclination would be to allow them to withdraw the appeal without prejudice. I'm trying to find the specific request. If you'll bear with me. They want a voluntary dismissal. So my inclination would be to find the request as to the development plan moot, because our rules control that, and as you said, the matter was concluded. and I would grant the dismissal of the zoning case, but without prejudice.
I agree with you.
Mr. Polshak?
I agree exactly with you. Absolutely.
Is there anything else before us at the moment?
I don't think so.
Neither do I.
Late, Madam Chair.
Would somebody make it warm out, please?
Wish it was within my power.
I wish it were within our power. Okay, gentlemen, I think we are in agreement to grant the dismissal as to the zoning case and under Rule 3, not to as to the development plan, which has been concluded and cannot be withdrawn at this time.
Thank
And
you,
with
Madam Chair.
that, we are going off the record.
Thank you, Madam Chair.